hearings. So we stream them live so that anyone from the public is able to tune in if they would like. So that is now going. Last thing I need to do is read through my hearing script. This basically just covers the procedure for the hearing. And then we'll jump right into it. So this is the, this is the August 31st, 2022 session of the Zoning Hearing Examiner docket. My name is David Sturkey. I'm the Zoning Hearing Examiner for the City of Cincinnati, and I'll preside over this hearing. The case before us today is case number ZH20220122. The purpose of this hearing is to allow applicants and opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the Zoning Hearing Examiner. All evidence or testimony that the applicant or any opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. If there were anyone here from the public, they would then have an opportunity to testify after the applicant had presented its case. I'll give Trey Sheldon an opportunity to provide any testimony in addition to the staff report. In the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to rebut that testimony. And then finally, the applicant will have an opportunity to make any closing statements. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties or other sort of unforeseen circumstances with our video conferencing technology, I may continue or postpone this hearing at my discretion. Okay, last thing I need to do is swear in all of our witnesses. So if you intend on providing any testimony here today, making any comments, asking any questions, doing anything other than just strictly observing, then you need to be sworn in. So if you believe that is you, if you can make sure you're off mute, you need everyone to raise their right hand and to answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, great. Okay, so who will be taking the lead here on the applicant owner side for the presentation? Ms. Roush, the floor is yours.
Yes, I will. This is Shannon Roush. I am an architect with Kent Bradley Roush Architects, and we're representing the Woodalls and did the drawings for this project. So just quickly to go through, the existing house was built in 1900, so it's been there for a little bit, well before all the wonderful things that are going on around it now are happening. The house itself is 26 feet wide, 47 feet deep. Before we actually put on the addition that we're proposing, there's a proposed addition to the rear, which will not be in violation. But it's on a lot that is 36 feet wide. So they essentially have 10 feet to play with. So on the underlying zoning, minimum is 3 foot with a total of 10, which obviously on a 36 foot wide lot with a 26 foot house, going to be pretty hard to maintain. However, what we are proposing that will be in violation is a second floor addition. There's not a second floor in the house now, usable second floor, or second floor addition of a bedroom and bath toward the rear of the actual existing structure. And that addition lines up with the walls below, mostly for structure, because that's the best way to do this, and also being 26 feet wide to maximize our space. The issue is that the wall on the right-hand side, which is the south side property line of the existing house, is only 3 foot from the existing property line. So practically any addition done along the right side within the footprint of this house would be in violation, especially on the right side. I'd also like to note that the effort was made on any additions that we're doing, like the sunroom addition to the back, that actually will be the 5 foot minimum. Some of the mitigating circumstances are the fact that this is a narrow lot with a house on it, and we're not making the condition any worse by lining up with the existing walls of the house. Another mitigating circumstance is that along that right side of south property line, the neighboring property, which was going to be most affected, actually are a series of multifamily houses, which are the actual rear of those multifamily buildings. And those multifamily buildings are accessed through an alley. The garages of those multifamily buildings are accessed through an alley. So there actually is an alley driveway, I shouldn't say alley, it's really a driveway running along that right property line. So that is providing a separation much unlike anything else would happen. So even though we're in violation by 2 feet, we're asking for that 2-foot variance. The property that's most affected has sort of imposed space because of the alleyway or the driveway. Again, this is a condition that was not created by the Woodalls. So it wasn't something that we're not doing something that created this condition. And the house will remain single family. I would say that the Woodalls, because Lisa has owned this house before, she is moving back to the neighborhood. It will remain single family, so like traffic will not be increased. It's not providing any decrease in light to neighboring properties, especially because of that driveway access. And I think we're asking that we're granted the 2-foot variance to allow for this second floor addition.
Okay, thanks, Ms. Roush. Ms. Woodall, is there anything you'd like to add to that testimony?
No, it's Shannon explained that I owned the property before. I bought it in 1988 when I was, in my mid-20s, and we loved the house. It was a great house, and we're anxious to be back in it and do some things that we couldn't afford to do when we were young people.
Okay, great, thank you. Trey, any testimony you'd like to add?
Just briefly, just that these are very typical cases where you have an existing home, usually a smaller home compared to modern amenities that people are accustomed to, especially in the Oakley area where it's been quite booming in the last 10 to 15 years. And just say this is very similar to most situations where you have a load-bearing wall of a home that predates the zoning code by 100 years. There's no effective other way to do it, short of somehow shifting that weight. It would create a lot of engineering. Shannon could speak to that better, but you'd have a lot of issues trying to support anything with I-beams or something else in order to carry that weight. You'd have to shift the load-bearing wall and put in columns or something. And so this is a pretty typical request. It is the minimum that would afford relief, in my opinion, because they're only asking to match that one section of the load-bearing wall in order to put a second-story addition on. As Shannon pointed out, the sunroom addition off the rear is completely compliant, both with side and rear setbacks, and it does not put this over 60 feet, such that it would trigger even greater side setbacks. So this seems pretty minimal, and from the street, it's just going to appear as a slightly higher roof line or roof pitch, since it's parallel to the ridge line will be parallel to the existing ridge lateral, side to side. So seems like a very reasonable request. That's it.
Thanks, Trey. Okay, Ms. Roush or Ms. Woodall, anything else in closing or otherwise before we adjourn?
No, not for me.
Nope, I think we're good.
Great, thank you. Okay, I agree with the testimony here today. I believe that this is compatible with the neighborhood and a reasonable request. So I'm going to approve the application. I need to formalize that opinion, or I'm sorry, I need to formalize that decision in a written opinion. And so I will begin work on that. If you haven't submitted everything for permitting, you can do that. And then as soon as I finish the decision, I will put it in a PDF and I'll email it to everybody who's in the hearing here today. So you all will have it really just moments after it's complete. As soon as you have that, then Trey can greenlight all of the permitting. Any questions about any of that right now?
Nope.
Okay, great. Well, if you have any questions that come up, feel free to reach out to myself or to Trey. And if you'd like an update on the status of the decision, like I said at the beginning, I try to get those out to you within 2 weeks. But if you'd like an update on that, I'm happy to provide that if you want to email me directly or call me. Okay, great. Well, thank you all again for your time and your testimony here today. Hope you have a wonderful day. Good luck with the project.
Thank you.
Take care, Shannon.
Appreciate it. Yep. See you, Trey.
All right.